it was so easy, life was so simple. You were 60 years, you retire, and then listen to Ramayana, Mahabharata, Bhagavad Gita. So no problems, no tensions. But then, when you choose this kind of a life, it is very difficult to retire first. Now I want to read, I am not able to read because of my sight. And I sit at the computer with my one finger, I go on writing articles. Tuck, 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 like this. Everything the difficult way. that is Kannabiran. This is the road to Guttikonda Bilam, and this is where the first meeting of the CPI-ML took place. It was in 1969. Now it is 35 years exactly. Just as the first meeting at Guttikonda Bilam was followed by armed revolt, in a manner of speaking, this meeting in Guttikonda Bilam today hopefully will successfully talk about bringing back a violent-free society in Andhra. And I think it is an important turning point which is being watched with tremendous amount of concern and anxiety all over this country, because the history of Free India has been that they never tried to resolve any political issue politically. With the commencement of these peace talks, not that the peace talks will be successful, whether it is successful or not, what is important is people have been given an opportunity, and this is what we have been trying to achieve in the human rights movement for the past 30 years.
As women, we've been raising so many questions all these years. We've been so troubled by the violence and the bloodshed and the torture, by the ruin of people. And the fact that a peace process is going to happen fills us with a lot of hope that far more important issues of day-to-day livelihoods and survival and women's security and women's needs will begin to get addressed. For many years we've been trying this, but we haven't. Perhaps there is a moment in history. Perhaps this is that moment when we will be able to bring these concerns to the forward, we will be able to talk about them.
ఇక్కడ మన కోసం ఏర్పాటు చేసుకుంది కాబట్టి మీరు చక్కగా మీటింగ్ వినాలంటే మీరు జరగాలంటే అందుకని మీరు ఏంటంటే మీకు కేటాయించిన గ్రౌండ్ పాట ద్వారా మీరు మీటింగ్ని చక్కగా వినగలుగుతారు. అందుకని మీరు దయచేసి వాలంటీర్స్ చెప్పినట్టుగా వినాలంగా కోరుతున్నాం.
So the ML movement is on the one hand political. As a political movement, it is a conscious decision by a section of the communist movement in India that the parliamentary path will not bring a revolution and therefore they have to take to armed struggle. The more interesting aspect of the ML movement is its social aspect, because merely because some people take a political decision doesn't mean that people will move. But the Emil movement was able to get hold of a whole class of people who were till then not part of the communist movement and who also felt sufficiently, let us say, disaffected with the existing system that they would support an armed struggle for state power. The poorest of the poor, Dalits and scheduled tribes, became part of this movement.
Number of young people who joined, teachers, teachers were leading the movement here. These people joined with a consuming passion for bringing about a social change. They are not people who ran away from life or who were unemployed, so they wanted to join this. All this simplistic analysis really does not hold water. They were all people who believed in the values preached by Marxism and Maoist philosophy, and they joined this movement with the full understanding what they are in for, and they were not bothered. They arrested around 5,000 people at the time, and many of them tribals. There was no adequate defense for them because they were being prosecuting in various sessions jurisdictions. And alongside of this, they were also killing people in the name of encounters. At the time they thought that it should appear legal. Now that idea is not at all present in the minds of the police or the government. So they used this AP Suppression of Disturbances Act, which authorizes the government to notify disturbed areas in the state. So the entire agency area, entire tribal area was notified as the movement progressed, and that enabled them to arrest people and kill them. All of them were really picked up and shot. For instance, Adipatla Kairasam was shot, Venkatappa Satyanarayana was shot, and Ramana Murthy was shot, Tamada Ganapati was shot, and quite a number of people were killed in fake encounters. There was no organization to protest against the atrocities management of the state in those days. There was no Civil Liberties organization. There is no organization worth the name which could raise its voice against this kind of atrocities. When my friend Ravi Subbarao, who was in the CPI, he was very much interested in defending these cases. And in fact, he roped me in actually. He was the person who said, you must come and help us. So I agreed. And then we met at Hotel Haridwar in Sultan Bazar. And there, Bhakti Bhushan Mondal, who convened the meeting, looked at me and said, since you have also some grey hair, you should be the convener of this defense committee.
Actually, around 69, 70, when Kanna started getting all these cases of defense and of political prisoners, my whole life changed. Till then, it was a nice, comfortable, middle-class life. Children, husband, job, school, whatever. But when this started happening, there was a qualitative change about life. Everything began to change for me. People would come in, people would talk about things, they'd leave, Kanna would come, and then he would be so full of it, he would be talking about it. And suddenly, we were part of history. From a nice middle-class cocoon-like existence, we were suddenly becoming a part of history. I didn't see it like that then. I was just sort of very excited by what was happening and very excited that, we're doing something important. And everything changed. And gradually, I think also the difference between my life in college as a teacher and my life at home, I would go and teach Shakespeare or Milton and come home. and find somebody who'd been beaten up by the police lying at home and waiting to tell Kanna their story. I mean, the contrast between this dual life that I led became very obvious. And slowly I began to realize that my life was more here than there.
Our association with Kannabiran started with the ban on the books. The 60th year of Sri Sri. Some 25,000 people attended, that is the writer's 60th day in Visakhapatnam. It was on 1st February 1970. So all of us were invited there, and there a pamphlet has come from the Visakha students, Visakha Vidyarthulu. That you are organizing, you are gathering here, you are writers, you are intellectuals here, you are organizing here, you are realizing Sri Sri as a progressive writer, it's all right. But just nearby Visakhapatnam, in Srikakulam forest, the Adivasis are fighting for their rights, for their self-respect, and not only they liberating themselves, but they are trying to liberate the whole human society. What is your attitude about that struggle? So we have to make a declaration and there itself that we support the Srikakulam struggle. So we openly say that we have a right to take up arms. People have a right to take up arms. And we are asking the people to boycott elections. We are asking the police constables to join the don't be on the side of the government and don't use the guns against your own parents or children or kith and kin. Such were the poems, which were in fact particularly the poems not to vote and use the bullet instead of ballot, and calling the constables as dear constable comrades, and don't join the army. Such were the poems written in the books, so they were banned.
They were preventively detained for their poems. So I made them read the poems in the court. The court was packed with advocates. Charabandraju wrote a poem for which he was detained, and that was called Indiramani Socialism Chalu Chalu. He read that so beautifully. Even today, I cannot really forget that the way Charabandraju sang that, keeping time with his 1 foot, singing. You know, it was tremendous. It was tremendous. And then advocates have not seen that kind of a display. That was new. And we did that because that is the only way to demonstrate what the state is doing. And tell people what the state is doing for people who are dissenting. And it was struck down.
Kanna's struggle against sedition is a struggle against colonial law. Now, this is something that will be continued in the Indian Penal Code without change, like official secrets. We talk about post-colonial India and so on, literary people and artistic people, but much of India is really colonial, and things stay as they are. And I think the struggle, what is sedition? Sedition, you won't believe me, but if you look at the text of the Penal Code, 124 or something, it in a sense says that people have a duty to love their governments. It says sedition is causing disaffection against lawfully elected government, which really means that you must love your elected governments. Now that's a demand that is justified if there were all those lovely people, you know, who can actually love, but that's not simply entirely unlovable lot. So what Kanna is doing is to say, and consistently, more than anybody else I know in terms of legal challenges, The question was unconstitutional, and people said it is constitutional, so there was no struggle possible. But sedition becomes a charge that you can use all too easily to justify unconstitutional governance and to promote unconstitutional governance.
Now the argument is, we are only detaining you, we are not taking away your other rights. Once you detain, you take away my other rights also. It is very hyper-technical and hair-splitting to say that you are giving me my freedom of speech but putting me in jail. If you put me in jail, my freedom of speech is lost. My right to form association is lost because I cannot address an association of people. My right to assembly is lost because I cannot gather people together to listen to me. So all the basic fundamental rights are at one stroke taken away by preventive detention. And this stage, this interpretation was never taken into account. This factor that in an area where it is important to people, in the political sphere, if you take away one right, you take away all the other rights.
ప్రివెంటివ్ డిటెన్షన్లు పెడుతూ ఉంటే హైకోర్టు కొట్టివేస్తున్నది, చట్టాలే కొట్టివేస్తున్నది. రెండుసార్లు అట్లా జరిగింది కాబట్టి రచయితలను వీళ్ళు చెప్తున్న మాటలకు, వీళ్ళు రాస్తున్న రచనలకు, జరుగుతున్న చర్యలకు ఒక ఇమినెంట్ సంబంధం ఉన్నది.
They do not say that Naxalite politics is a conspiracy. That they cannot say. That is not permissible. Or the CPI-ML party is a conspiracy. But what they really mean, if you look at the charge sheets that are filed in all conspiracy cases, is that party itself is a conspiracy.
Individual criminal cases are filed 10, 50 and 20. They are all put together. And a lot of intellectuals and supporters and sympathizers and leaders of the parties are also made accused. They are made the conspirators. So conspiracy cases are essentially as an assault on the political faith, not on an act of crime. So initially the civil rights movement started as a protest against these things. Initially, rightly or wrongly, I mean, one should say understandably, because all over the world it has been the case that whenever there has been a suppression of dissent, some kind of dissent by the state, it is among the sympathizers of the dissent that you have had the first civil rights organizations.
Parvatipuram conspiracy case, the original charge sheet filed by Mr. Veer Narayan Reddy, who was the investigating officer, who gave a complaint to himself. He wrote the complaint and gave it to himself as an investigating officer of a particular police station. He presents and he receives. So there was a list of 250 people. And by the time the charge sheet is filed into the court, this 250 people gets reduced to 150. 100 were short. Then one judge, Sitaram Reddy, justice, took the view that conspiracy is not made out, and so there is no necessity for going into the rest of the evidence. Because once conspiracy is not made out, the other evidence becomes irrelevant, because you can't, from the other evidence, you can't infer a conspiracy. You have got to establish that there has been a conspiracy, and so this evidence is admissible. The other judge, of course, felt that conspiracy is proved, and he, I think, convicted about 10 people. So it had to go before a third judge, and that judge was Muqtadar. And we argued before him for another 3 weeks, daily, 10 to 4:30, 10:30 to 4:30. And we were able to convince him that conspiracy is not made out, and that individual offences are also not made out. So it ended in an acquittal. But then the funny part of it is, similar cases, conspiracy cases, 22 conspiracy cases were framed within a period of, say, from 69 to 74.
74లో సికింద్రాబాద్ కుట్ర కేసు వచ్చింది. ఆ సికింద్రాబాద్ కుట్ర కేసులో విప్లవ రచయితలే 6 ఉన్నారు. చివరికి ఎంత అంటే టెలిఫోన్ డైరెక్టరీలో కూడా విప్లవ రచయితల కుట్ర కేసు అని దాని ఫోన్ నెంబర్ ఇవ్వబడుతుంది.
It's a part of history of this civil liberties movement that Kanna fought our case for 18 years without a single paisa charging us as fee. Not only that, in our case there were so many accused who were small farmers or their wives and all that. They used to come to Hyderabad. They were penniless. Kanna used to provide them boarding and lodging and even to and fro charges. That way, at that time, let me tell you, Kanna had a very prosperous practice. He was legal advisor to Paris and Company from Tamil Nadu and so many other five-star hotels, clubs and all that. His practice suffered a lot because he took up our case. He became known as Naxalite liar.
But I would personally feel that the government was interested in prolonging the matter. You know, you harass them completely. So you have the accused who were married then have become fathers. Some accused have become grandfathers. And I was the only one constant feature. And then after the PP's argument in October, the judge asked me, when will you have your arguments, Mr. Kannabiran? Then I told the judge very solemnly, saying, sir, I took up this case when I was 40 years old or 45 years old. And now, sir, I am 55, I think, 45, 15 years, 40 years old. I am 55 now. And my birthday falls on 9th November, that is a Monday. Please have it on that day so that I can commence my arguments. So the next day the accused got flowers, birthday gifts, bouquets and all that. Empty con, not a huge bouquet.
1972 నుండి చూస్తున్నాం మేము చిన్నగా ఉన్నప్పటి నుండి. ఈ 30 ఏళ్ల సుదీర్ఘమైన జీవితంలో ఎప్పుడెప్పుడు ప్రజల ఉద్యమాలు వచ్చినాయో, ఎప్పుడెప్పుడు విప్లవ ఉద్యమాలు వచ్చినాయో అట్లుండవు. అదే కాదు, ఏ నక్సలైట్ల గురించి చెప్పుతే భయం రా బాబు, నక్సలైట్ గురించి మాట్లాడితే భయం అన్న పరిస్థితులలో ఆ నక్సలైట్ ఉద్యమాన్ని గురించి, ఆ విప్లవ ఉద్యమాన్ని గురించి కంటిన్యూగా మాట్లాడడం. అదే కాకుండా వాళ్ళు చేసే తప్పుల్ని కూడా నిర్భయంగా ఖండిస్తాడు. అదొకటి. దాచుకోడు. కోపానికి వచ్చిండు అనుకో, నువ్వు ఇది తప్పు చేస్తున్నావు, నువ్వు ఇది తప్పు చేస్తున్నావు, మీరంతా పాడైపోతారా, మీ చెప్తే వినూరి మెల్లగా తీసుకుపోయిన మూమెంట్ అని కూడా గట్టిగా చెప్పగలుగుతాడు. తన మనసులో ఉన్నది మనకు కొంచెం ఎమోషనల్ అయిపోయింది అనుకో, ఇంకా ఏం మిగలదు, అంత చెప్పేసేస్తాడు.
Mr. Kannabiran, these Naxalites who want to overthrow the government, overthrow the constitution and all that, why should they seek protection under the constitution? Then I told them, sir, when such values come before this court, it is not their values which are on trial, but your values. Your values are in trial. Your constitution is on trial. You write in the constitution saying people who don't believe in the constitution are not entitled to protection. There's an end of it. So long as you say that notwithstanding their views, they are entitled to rights and protection under the constitution, it is your values, your constitution which is always in trial.
The Indian Constitution is the most unusual document for, among other reasons, it has Article 21 which says everybody shall have the right to life and liberty, and Article 22 which authorizes preventive detention. It is same. So one can understand this because it was a country born in Holocaust, and the Constitutional Assembly wrote in the middle of partition violence. So one understands 22 in its original setting. But then it becomes a habit of the state to govern by preventive detention. And it becomes a legislative habit and judicial habit to say it's okay. And that's what was not intended by the constitution makers. And it fosters what Kanna says, culture of impunity, because it's a very vast power and you can do with it what you like. The courts can only review so much of detention and so on. Although the courts have policed, as it were, detention powers, they have not questioned them. They cannot, because the Constitution authorizes that. It's also a response of state panic. So when political managers are not able to cope, this is a high-handed instrument, cope with resistance, popular unrest, and so on.
Pattipati Venkateshwarlu rang up and said, Indira Gandhi has declared a state of emergency and I have just been arrested, so tell Kannabiran as soon as he comes home. And it didn't quite, I mean, I was very stunned that he was arrested at midnight in state of emergency, but what that meant didn't quite hit me until it kept happening. Every night around midnight there would be calls and there'd be friends, there'd be people you knew who being arrested, they'd be called saying so and so, and Kanna would just take it very quietly. He'd go, then the next day he would be arguing.
You know, you go to the criminal court, and then I found one inspector saying, here afterwards it is our rule. So I moved Venkateshwarlu's writ petition, writ of habeas corpus, by way of a lunch motion. And it came in the afternoon. I was making my submissions to the court, and I was vehemently contending that there are no grounds for the arrest of Mr. Venkateshwarlu, because it was at the admission stage, initial stages of the hearing. And if they have grounds, direct the public prosecutor to produce them, produce the order and the grounds. Then the public prosecutor foolishly got up and said, the grounds are being typed. The public prosecutor was Ovulpal Chowdhury then, was no more. When he said that the grounds are being typed, I said, the court may record the statement of the public prosecutor and release Mr. Venkateshwarlu, because grounds are not in existence when he was arrested and it's being typed now. So he is entitled to release. So the judges felt that the public prosecutor may be taken to task for having made this representation. And so to save the public prosecutor, they forfeited the liberty of a citizen.
400 రిట్ పిటిషన్స్ ఆర్గ్యూ చేశాడు ఆయన సింగిల్ హ్యాండెడ్. ఆ 400 రిట్ పిటిషన్స్లలో డైహార్డ్ నక్సలైట్ దగ్గర నుంచి మొదలుకుంటే లోపల కనుక ఉంటే ఎమర్జెన్సీలో ఆర్ఎస్ఎస్ సుబ్బరాయుడు అనే సీనియర్ అడ్వకేటు 14 సంవత్సరాలు ఆర్ఎస్ఎస్ పిల్లవాడి దాకా అన్ని కేసులు ఆయన వేసినాయి. పైగా ఈ ఫైట్ చేయడం ఎక్కడ అంటే ఒక సూత్రబద్ధమైన దానికి కమిట్ అయి ఉండడం అనేటువంటిది స్పష్టంగా చెప్తున్నారు అడ్వకేట్ జనరల్. ఈయనంతా కంఠశోషగా ఆర్గ్యూ చేసిన తర్వాత ఈ కోర్టుకు ఇది విచారించే అధికారం లేదు. ఆల్ ది ఫండమెంటల్ రైట్స్ ఆర్ డినైడ్.
So when the emergency says that fundamental rights remain suspended, since the Constitution gave you the fundamental rights, the Constitution can take them back. I mean, it's a very superficial logic. Constitution does not give us rights. Constitution confirms that we have fundamental rights. That is a human rights lawyer's understanding of what rights are all about. If you see them reasoning out on property cases, the reasoning is entirely different. You know, property is inalienable. Property right is an inalienable right, whereas a man's right to personal liberty was considered to be alienable.
During emergency, what was the status of Defence Committee?
Defence Committee became non-functional excepting me. There was only one functioning member. The other functioning member was inside the jail, Venkateshwarlu, Pattipati Venkateshwarlu. So So some wise guy came to me and said, now that emergency has come, why do you want to continue the committee? Why don't you dissolve it? So I told that member, please don't come if you don't feel like. I will not dissolve the committee, and I'll continue as a one-man defense committee. And that is how I was representing the defense committee in all the writ petitions. I appeared as an advocate.
I asked him, I said, every single person who's been arrested during the emergency has rung up here. And I've given you this message saying that, so-and-so, and you have gone and filed a case, a habeas corpus for them. When you are arrested, who should I approach? Tell me and give me the numbers so that I know who to call as soon as you are arrested. He couldn't think of a name.
They won't talk to me, advocates won't talk to me.
And then he gave me the name of one lawyer with whom he had worked very closely professionally and who he had supported enormously in his work and whatever. That man was making the money, Kanna was doing the work. Srinasmurthy, Kanna gave me this man and said, see, he doesn't have the guts to come out in the open, so he will not come and file a case for me. But he's very fond of me and I've done so much for him, that he will at least move and pay somebody, get some lawyer to appear for me. He will see that whatever is necessary is done for me. So you contact him and tell him. And strangely enough, the next day or the second day after that, Kanna came and told me that the day Kanna was walking along the court corridor and Srinasmurthy just crossed to the other side so that he would not have to wish him. People stopped wishing him, people stopped talking to him. People were afraid of being seen talking to him. And we'd get information that his name was also on the police list for all the cases that he had done. He was going to be arrested any time. And because of this constant midnight arrests, I remember right through the emergency telling Kanna, I'm just so tired today, I hope they don't come for you tonight. I hope they wait tomorrow night or whatever.
The atmosphere in courts, barring these Naxalites who raise slogans or the detainees who will come and keep talking in the courts, people will come because they are all handcuffed and brought in a police van, and their handcuffs will be removed and then they'll be produced before the court. So leaders were there, and so public used to come. It became a sort of a public meeting for me, so that I could really tell them what exactly the facts of that particular case, why they were arrested, that rounds are not submitted. All these things were broadcast in the court halls, various court halls, by me that was the method I used. And there was a lot of hope that this institution really will do something about it. This institution will set itself against authoritarian rule. That kind of a hope and that test, it was actually the institution was tested during that period, and the institution let down the people.
Nobody would disagree that the emergency was in fact unconstitutional. But we didn't have judges who had the courage to say that. They had the retrospective courage to review the emergency and even say that it violated human rights. But at the time when they needed the courage, they lacked it. Not all, but the Supreme Court certainly. And then they apologized to the nation after the emergency was over. The Supreme Court itself becomes populist and cathartic and makes several judgments which in fact make future excesses of emergency impossible. So there is in a curious way, one learns out of misery of disarticulation, but you can't protest when you should.
Andhra Pradesh made two contributions to the modern vocabulary. One is Vengal Rao's English, whatever you may call it, bump off. He used to say bump off. He did not know English, but that was his English. He used to tell the officers, bump off. That fellow is creating trouble on the campus, bump off. So he was bumped off, just like that. And then encounter.
You apprehend Naxalites and then torture them in forest guest house, PWD guest house, which generally are at the periphery of a township or a village. We were talking generally about these encounters and the way one should try to confront these practices. And as we were discussing this in that meeting, Jwalamukhi got up and said, why not we constitute a non-official committee to go into the question of these encounters. And in that meeting, I was appointed as a convener to convene this body. And I thought I should constitute a committee of persons who do not really belong to the Communist Party, because I felt that they may not complete the task. So immediately we arrived at a team to form the committee. We went to Tarkunde in the Supreme Court and asked him whether he would be the president of this committee, chairman of this committee, and he agreed. And then with this list we went to JP. Within about a month we completed investigation into the Giraipalli murders.
సూరభినేని జనార్దన్ రావు అనే వరంగల్ రీజనింగ్ కాలేజ్ స్టూడెంట్, మురళీమోహన్ రెడ్డి అని వరంగల్ లాల్ బహదూర్ కాలేజ్ స్టూడెంట్, ఆనందరావు అని వరంగల్ గవర్నమెంట్ జూనియర్ కాలేజ్ స్టూడెంట్, సుధాకర్ అని మార్కెట్లో పనిచేసే ఒక ఆయన కొడుకు. ఈ నలుగురు దళంగా అక్కడ వెళ్ళారు. 75 ఎమర్జెన్సీ పెట్టిన ఒక నెల రోజులకే 24 జూలై రాత్రి వాడిని అరెస్ట్ చేశారు. వీళ్ళతో పాటు భిక్షపతి అనేటి హనుమకొండ వడ్డేపల్లిలో ఉండే ఒక పిల్లవాడిని అరెస్ట్ చేశారు. 5గురు తీసుకుపోయారు. గిరాయిపల్లి అడవుల్లో చెట్లకు కట్టేసి విపరీతంగా చిత్రహింసలు పెట్టి చెట్లకు కట్టేసి కాల్ చేశారు.